this video is for a very special person. I just wrote 2 assistant U.S. attorneys, and, well, I guess I'm putting this out across the world. When precisely is it that all this bank fraud, that Deutsche Bank and Credit Suisse, J.P. Morgan Chase, and Bank of America, and Wachovia, Wells Fargo, WAMU, Superior Bank, Western Bank, when is it that all this subprime predatory lending fraud, where they misrepresented to the investors the way they rigged the appraisals and got the appraisers to give them the values they wanted, and they did all that, funny business with the stated income, no documentation of employment stuff, and they just did this easy credit scheme and scam. And when exactly is it that the schemes to pull all this mortgage fraud off, when did it start? Did it start before they began laundering? Oh, did I say laundering the money? Oh my God. Yeah, the laundering of money. When did the fraud begin? Right up front? Did they design the whole system to be a scam? And the answer is maybe the House Financial Services Committee, or the Senate, or the Congressional Banking Committee, or the FBI, or the Department of Justice can answer some of these questions. I don't know, maybe the State Attorney General. And the American Bar Association, maybe they'll chime in here. When exactly is it that all of this scheming and scamming came into play? Was it right up front, out of the starting blocks? Or did it begin, down the timeline a little bit? And who is it precisely that designed this mortgage fraud, lie to the investors, lie to Fannie Mae, lie to Freddie Mac, lie to the Federal Housing Finance Administration, lie to the FHA, lie to the VA, I guess they lied to a lot of investors about the quality of the loans. It's couched. It's couched in those terms that the quality of the loans was misrepresented to the investors. Well, when did the misrepresentations begin? This is the question. Now, I've got something of kind of great importance here. This is the partial matrix of a federal case in the United States District Courts in Greeneville, Tennessee. It's involving an appeal in state court that, they denied filing it today. They advised me that the litigation tax had to be paid by an indigent appellant, which is just flatly in violation of Tennessee Rule of Procedure 29. That's 29. The Rule 29 clearly indicates that litigation taxes are waived for indigent appellants in civil cases. You file an affidavit of inability to pay the costs of court, and the costs of court, and the litigation tax is waived. And then, of course, real parties and interest are the only ones that are concerned with this case, and that would be this one single mom. And let's see. So the Office of Tennessee State Courts Administration and the County Circuit Court Clerk over in Blountville, Tennessee, and the clerks and the judges of the federal courts in Greeneville have been made aware of this situation where, you can't access the courts in a meaningful way. Now, I want to recite from this brief here. The rule is that meaningful access to the courts be afforded to the self-represented plaintiffs, appellants, defendants. It has to conform to a long litany, a great volume of instructions by the American Bar Association, the Supreme Court of the United States, the appellate courts of the United States, the Supreme Court of the states, the appellate courts of the states. Meaningful access to the courts is required particularly under Tennessee Rule 29 when it is applied to indigent appellants. Today is the 28th day of May 2019, and I'm feeling kind of lucky. And this particular video is for one lucky lady, actually, who, well, she thinks I'm her lucky man, so I thought I'd put on the lucky hat and make a video tonight to try to let this person know that, well, backing people up sometimes is not easy. And, well, I guess that's when they call in the real McCoys, the genuine articles. So I'm going to kind of leave it there. This is sort of a personal video from the research team. That's a double slash with an S. In case anybody's wondering, double slash with an S, that's the research team. And, well, let the battle begin. I mean, Rule 29 of the Tennessee Rules of Court is concise, plain, and simple. They can't force an indigent appellant to pay the litigation tax, and only the indigent appellant, that's singular, is a real party in interest in this appeal. There isn't anybody else that was on this particular financial contract, and there's only one borrower. There were not borrowers, singular, not plural. But the real party in interest and Rule 29, and the Tennessee State Court administrators and the federal courts. We'll see how this scenario works out. Anybody interested, read Tennessee Rule of Civil Procedure 29, and in the links below, it does say that the litigation taxes are waived for the indigent plaintiff. All right, leave it right there. As always, hasta la vista. God bless. And, well, let's just one more thing. When did all this fraud? When did it begin? Did they design it to work this way from the get-go? The U.S. attorneys and the assistant state attorney generals and all this fraud and stuff against these lenders. I mean, when did they cook up the fraud schemes? This is a question to everybody. When is it that they decided that the way to market these mortgages was to sucker the consumers in the first place and lure them in and bait them in and get them into the subprime predatory mortgages so that the rest of the crooked scheme could be very profitable for the people that were perpetrating them? It's a mouthful, isn't it? I'll leave it right there, and as always, hasta la vista. God bless, and you betcha we're coming back.